and I want to know your answer to it, under their reading, the millions of Americans who buy Toyotas could not resell them without getting the permission of the copyright holder of every item in that car which is copyrighted. Is that right?
There may be just.
Please, am I right or am I wrong? Am I off base or am I wrong? Am I right?
There are other defenses, but that is not this case. This case is not.
Or how do you distinguish?
The government would argue for a broader interpretation under what is made under the statute, whether that would include the importation or the distribution in commerce. That's an argument that the government makes, but it's not necessary to decide this case.
Explain to me, because they're horribles if I summarize them. Millions and millions of dollars worth of items with copyrighted indications of some kind in them that we import every year. Libraries with 300 million books bought from foreign publishers that they might sell, resell, or use. Museums that buy Picassos that now, under our last case, receive American protection as soon as that Picasso comes to the United States, and they can't display it without getting permission from the 5 heirs who are disputing ownership of the Picasso copyrights. Those are some of the horribles that they sketch. And if I'm looking for the bear in the mouse hole, I look at those horribles, and there I see that bear. So I'm asking you to spend some time telling me why I'm wrong.
Well, first of all, I would say that when we talk about all the horribles that might apply in cases other than this, museums, used Toyotas, books in luggage, and that sort of thing, we're not talking about this case. And what we are talking about is the language used by the statute that does apply to this case.
But we need to know about that, the hypotheticals, in order to decide this case. You're aware of the fact that if we write out an opinion with the rule that you propose, that we should, as a matter of common sense, ask about the consequences of that rule, and that's what we're asking.
And exactly, Justice Kennedy, and that's what you were doing in the Quality King when we were discussing with Justice Alito whether this is dicta or not. The Court was specifically saying what it would apply to, and what the Court was talking about in that case was books made not pursuant to this title, but pursuant to some other country's copyright law. These copyright
Why is it that
law provisions,
a U.S. copyright owner who contracts in England to make books, he doesn't have an English copyright, he just simply chooses that place to manufacture as opposed to the U.S. Why is he making that copy under English law and not under his rights of U.S. copyright?
Well, if he's manufacturing the book in England, he's not, because the copyright law does not have extraterritorial application, he is not making those copies under this title. And this
He's
Court
selling it no differently than Quality King was, or the Quality King.
What the problem is, the statutes may not be perfect with respect to this, and there may be horribles that occur under one set of interpretations of the statute, and the other interpretation of the statute is to interpret it as the petitioner.
We know from the CARP exchange that the response was, this is something we have to study with care. In 1976. The parade of horribles is now causing the Solicitor General and at least one, if not 2, courts of appeals to write exceptions into the language to take care of what they perceive as horribles. Isn't it incumbent upon us to give the statute what is plainly a more rational, plain meaning than to try to give it a meaning and then fix it because we understand that the meaning doesn't make sense?
There is a body of the government of the United States that is entitled and capable of fixing this. These parade of horribles have been people that have been arguing about these for years. For 30 years, the statute has been interpreted the way that we are suggesting that it should be under this title, which this Court earlier this year in another case in the Novo Nordisk case specifically said under this title means pursuant to the provisions of this title. This Court said that before in the Ardestani case. the under this title occurs not only in Section 109A, but under this title occurs in 602A itself, and then under this section appears twice in Section 602A.
Mr. Rosenkranz told us that under this title means different things in other sections, and he gave a number of examples.
Yes, and in each case, first of all, if the interpretation that my opponent is arguing for was the law, those are the words that are in 602B and 602A2. So Congress could have used those words that our opponents are arguing for, and did use those words, one of which was written on the same time, passed in the same time, in 1976 at 602A1.
Well, Mr. Rosen, can I just take
with respect to those other —
Please.
With respect to those other provisions, Justice Ginsburg, the government specifically goes over each one of those, but each one of those, if you interpret the statute as under this title, as pursuant to this title, each one of those provisions makes sense in the context in which that term is used there. And there is only one real way to interpret under this title in the provisions in 109A in conjunction with 602A1, and that is the way the Court decided it in the Quality King case, specifically looking at this question. Now, the facts were slightly different in the sense that was a round trip. This isn't a round trip.
Can I take you back to the words here, lawfully made under this title, which you say clearly means what you say it means? So I find this language a little bit perplexing, and I can kind of see it both ways. So what you say is made under this title. That must mean made in the United States. And lawfully just is this little word that modifies that basic phrase, made under this title, which means made in the United States. But what Mr. Rosenkranz essentially says, he doesn't say it in these words, but he says the focus of this provision is on lawfully made. That's what the focus is on. It's on lawfully made as opposed to unlawfully made. Now, when we just say lawfully made, we need something to measure. Well, how do we know whether it's lawfully made? Well, you look to the rules in the copyright law. So if you focus more on the lawfully word, lawfully made, and then under this title doesn't mean made in the United States, it means lawfully made under the rules of this title.
Lawfully made under this title is lawfully made under the copyright laws of the United States. It can't say lawfully made in the United States, because then something might —
Well, lawfully made under the rules of the United States, regardless where the thing was manufactured, is what I'm saying. That's the way it just seems to me as though you're saying made must be manufactured, but lawfully made is a lawfully made copy. How do we know if it's lawfully made? We look to this title.
I think under this title means that it was made pursuant to the provisions of the copyright law. I can't imagine the difficulties that would ensue with litigation over whether or not something made in another country, made under another country's different laws, and they vary enormously throughout the world, whether that was somehow compatible with the laws of the United States.
Or what about litigation in this respect? I want to bring you back to the horribles.
Because
your main point is that horribles haven't occurred, right? Sometimes horribles don't occur because no one can believe it. Now, for example, I believe there's going to be a storm, but it hasn't started yet. So I would like to know, if you were the lawyer for the Toyota distributor, and if you were the lawyer for the Metropolitan Museum of Art, or you're the lawyer for a university library, and your client comes to you and says, my God, I just read this Supreme Court opinion. It says that we can't start selling these old books or lending them or putting them in our word processor or reselling the Toyota displaying the Picasso without the permission of the copyright holder, who may or may not be Toyota itself. What, as their lawyer, do you tell them? Do you tell them, hey, no problem? Or do you tell them you might become a law violator? Or do you tell them I better litigate this? What do you tell them?
Well, each one of those situations that you posit, Justice Breyer, has a whole panoply of set of facts. With respect to the museums, with respect to the person bringing books into the United States, there are other defenses, including fair use. There are other defenses under the copyright law. And one of the things is that to a certain extent, if you're going to use the product created by someone else in a way that's contemplated by the copyright laws, maybe it's required that you actually comply with the copyright laws by going to the owner of the copyright and saying, look, here's what I propose to do. Can I have a license to do this? It's a nonprofit. It's a museum.
You said there are other defenses, including fair use. In the catalog that Justice Breyer recited, are all those fair uses?
No, and some of but
well, which ones are? I mean, it seems unlikely to me that if your position is right, that a court would say it's a fair use to resell the Toyota, it's a fair use to display the Picasso.
It may be a fair use. It may be an implied license, for example, with respect to copyrighted items or trademarked items that appear in a product that was licensed abroad. The government has offered another alternative interpretation of the word "made" as putting it in the flow of commerce. That might deal with some of these situations. But the point I guess I'm making, Mr. Chief Justice, is that Congress was clearly intending to talk about the vast gray market problem. The provision.
Well, intending where? I mean, you spend a lot of time talking about the legislative history and the purposes behind 602. But the language that we're supposed to be interpreting is the language in Section 109. And the language in Section 109, as far as I can see, there's really nothing to support your argument that that language was intended to address this gray market problem. Isn't that correct?
Well, no, I think that Section 109 and 602A were adopted in the same statute. They were put in the draft of the statute at the same time in 1964.
But, Section 109 is just a rewording of a prior provision that you would clearly lose under, where the prior wording had nothing to do with where any product was manufactured. And what you're suggesting is that we should read this change in wording, which actually there's a real theory behind what the change in wording meant that has nothing to do with the place of manufacture, that we should read it as incorporating a place of manufacture requirement because there was a separate debate going on in Section 602 about that question.
I guess I'm trying to explain is that the two were enacted at the same time. They were out there and available to the public for 12 years before they were finally adopted. These parade of horribles could have been addressed by Congress in a different way at the time, and the interpretation, 109 is a defense, is offered as a defense to Section 602A1. So what does it mean? What is the defense that's provided? And you then have to interpret lawfully made under this title, what does that mean? And you have done that in the Quality King case. You explained in the Quality King unanimously that it makes a difference because you're exhausting. Congress intended to allow segmentation of the market. It only makes sense to interpret this way if you allow segmentation of the market pursuant to these provisions, because it is exhausting the copyright under the laws of the United States once you make a sale of a product produced in the United States subject to the United States copyright laws. You're not exhausting your U.S. copyright when you make something or allow something to be made abroad. You're not exhausting that copyright. You have not done that yet. So the first sale is not something that happens abroad that uses up the copyright laws of the protection under the copyright laws of the United States. So it seems to me that this does make perfect sense, and it does not going to be a perfect solution in every case. The Court has dealt with that frequently with respect to copyright laws, but if you interpret it as my opponent interprets it, you are opening the door to commercial enterprises precisely like this. It's not necessary in this case to decide every single permutation of a problem that someone crosses a border with a product, but this Section 602 specifically contemplates products that are acquired abroad and then brought back into the United States. Here we have a commercial enterprise doing exactly what is contemplated by the people who were talking about 602A and Section 109 when the two were adopted at the same time.
Mr. Olson, do you have an answer to the outsourcing problem? The charge is that if we read the statute as you are urging, then you are inviting the outsourcing of manufacturing jobs?
Yeah, there are several answers to that. One, that's Congress's concern, and there is no evidence that would really actually happen. And Congress was concerned with creating a segmentation of the market. but it's entirely speculative as to whether or not people are going to start manufacturing books or other items outside the United States. Congress can address that if that should become a problem, but it's not something that was suggested as a part of what was taking place at that time.
Thank you, Mr. Olson. Mr. Stewart.
Mr. Chief Justice, and may it please the Court, I'd like to begin by discussing our Bobbs-Merrill argument, because it's part of our brief that's different from both the parties' submissions, and I do think it's very important to understand